Thank you. Good morning. We're hearing our case 1 CACV 17-0106, Sun City Golf Resort versus LOEGERING. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you wish for rebuttal, but you'll have to keep track of that time yourself. We are recording the argument. This argument will be on YouTube in a couple of days, so you're able to see yourselves. Because we are recording this, when you approach the podium, please identify your client and yourself so that we can keep everything straight. We have conferenced this case. We've read the briefs. We've discussed the matter, so we're fully aware of the facts and the issues. So when you begin your argument, please start out with what you think we need to know. Counselor, you may begin.
I am. Thank you, Your Honor. Good morning. My name is Philip Nathanson. I represent George LOEGERING, who is here today, and his trust. And this appeal presents itself to this court following a jury trial in the Superior Court. There were 8 claims submitted to this jury, 5 of which were a straight not guilty verdict for my client, Mr. LOEGERING. And basically, what we're talking about is 2 of the 3 remaining claims, at least from the appellant's point of view. That's what we're talking about. The first of the 3 remaining claims was a tortious interference claim where the jury found for the plaintiff but awarded 0 damages, which to me as the defense lawyer is, since damages are an element of tortious interference, was not really a plaintiff's verdict, but that's what the jury said. The other 2 claims were statutory claims. Actually, one of them was a statutory claim, violation of ARS 33-420, where the jury found for the plaintiff and awarded the minimal statutory damages they were instructed had to be awarded of $5,000. And the slander of title claim where the jury found for the plaintiff and awarded 0 damages. So from the defense point of view, basically there's a recovery of minimal statutory damages on 1 of 8 counts. This obviously looms large on the attorney fee issue, which I plan to touch on briefly today. But the reason we have brought this case to this court is the following issue. Both the slander of title and the 33-420 claim were based upon a peremptory instruction that the trial judge gave based on her partial summary judgment, instructing the jury that the judge had already found as a matter of law that the almost simultaneous delivery of a deed of release canceled the deed of trust the minute it was basically issued.
Counsel, are you objecting that her conduct was in error in regard to making the statement, or her conduct was in error in regard to her determination?
We are objecting to the summary judgment itself, Your Honor.
So you're saying her determination under the law was wrong?
Yes, and then, that's the first point, and then my opponents decided to litigate a trial after obtaining a partial summary judgment. They decided to put in all the evidence in front of the jury that pertained to that partial summary judge on which they had already prevailed, and I asked the trial judge to vacate the summary judgment during the trial on an opening the door theory arguing that if you obtain a partial summary judgment on an issue and then you relitigate the issue in front of the jury, we ought to be able to relitigate it in front of the jury too, which did not happen because while we contested the points with the witnesses, the judge gave a peremptory instruction to which we objected on 2 counts.
Counsel, if you disagree, please say so. If the trial court properly granted the partial summary judgment, and I know you don't agree with that, but if the court did, then there would be no problem in so instructing the jury on that point, correct?
That would be correct unless the party obtaining the partial summary judgment chose voluntarily to relitigate all the issues that were the basis for their partial summary judgment before the jury without my client having the opportunity to argue to the jury.
And did you object to
Absolutely.
that? What was the trial court's ruling on that?
The objection was overruled. I objected to the admission. I specifically said, Judge, you've already granted a partial summary judgment on this. I remember approaching the bench, why are we relitigating everything about this deed of release?
But wouldn't the evidence of the deed of release and the conveyance of it be relevant as to the slander of title claim as well? I mean, they have to show, if they're arguing he slandered the title, wouldn't they be allowed to show why that was a clean title he shouldn't have been slandering?
Well, I would think in most instances that's logically true, Your Honor. However, when the judge has already determined as a matter of law that the deed of release was extinguished the minute it was signed, thereby extinguishing, that the deed of release extinguished the deed of trust the minute the deed of release was signed, I don't see why they have to offer evidence that the deed of release didn't exist. The judge was going to advise the jury that the deed of release nullified the deed of trust immediately, and so to offer all that evidence, and I did object to it, and I did move to vacate the summary judgment, filed a written motion to vacate it due to that, which was argued as a motion to reconsider, but I didn't intend it as a motion to reconsider.
Let me move you to the merits then. I realize there's 2 kind of merits issues, but bouncing off Judge Howe's question, tell me what the judge got wrong on the deed of release. What didn't that immediately extinguish the deed of trust once it was conveyed?
There's a couple of reasons. The main reason we argue in our brief is that there was extensive testimony from the parties, from my client George LOEGERING and his brother Thomas Sr., to the effect that the deed of release was a contingent delivery.
This is the parole evidence that was offered in support of the executed document, correct?
This is what, I don't know if I want to concede, Your Honor, respectfully, that it was parole evidence. It was parole evidence that there was a condition as to the delivery, that it was a conditional delivery of the document. It wasn't parole, which is permitted under Arizona law. It wasn't parole evidence to vary or modify the terms of the deed of release.
So the deed of release was effective immediately because nothing varied it, right?
No, the deed of release doesn't say it's effective immediately.
It just says deed of release and reconveyance, right?
Yeah, yes, it does.
And it's dated and signed, correct?
It is not dated. It is not dated. It was signed, consistent with my client's testimony, that...
is there a blank?
There's a blank by the date. Oh, absolutely.
I'll look at that again.
So the deed of release was, according to my client, given in case something happened to him, that they could record it.
Well, but if it's not dated, then how is it useful whenever it's delivered then?
Well, that's sort of raising the question, was it delivered? My client said it was given to the manager of Sun City Golf Resort to hold upon either payment of the promissory note or something happening to him.
Okay, so the bottom line is, your client prepared and gave to the manager, I believe, of the golf. There you go.
Yes.
A document in case he died, so it was completely filled out, and in the event of his death, then he would sign it?
That was one half of it.
How does he do that?
The
If he's
other
already
half-
died, how does he come back and finish executing the document?
Well, the first half of it was if the note was paid in full.
But that's not my question. Let's just assume it's paid in full. He gives him a document in the event that he dies, but it's not complete. You're asserting it's not complete so that it was a valid instrument, right? Or does the date not matter, as long as he signed it and it asserts what's supposed to happen?
The date matters under Arizona statutes in terms of recordation. 33707
The
says.
recordation matters.
Well, the statute says the recordation is conclusive evidence as to the effectiveness and validity of the deed of release.
So
as to others, right? Not necessarily the parties, correct?
Well, Your Honor, I don't want to.
we do.
I thought I had the statute here.
Excuse me, counsel. My question is this.
Yes?
Your client did a very prudent thing. He executed a deed of release and reconveyance.
Uh-huh.
He communicated it to a third party, or third party or not, it was the manager of the golf resort. And in the event of his death, it was to be recorded once the monies were paid back to his trust, right? Is that has to be your point?
It was to be my client testified it was to be recorded once all the monies were paid back, or if something happened to him.
Okay.
That was his testimony. It was an either or.
So the bottom line is, it was in his mind, it was ready to be filed. It was ready to be recorded, but for the issue of his death.
Or before the issue of repayment he had put $700,000 of his own money into this golf resort, and he wanted to be repaid. So he was given a security in the form of a deed of trust, but he also wanted his family to be able to get out from under if either he paid the note back and something happened to him, or just something happened to him. That was his testimony.
How are we going to, because we issue rulings on law, and what kind of law would we write that would say valid signed documents don't mean anything if there's some kind of unwritten contingent? I just seems like if we do what you're asking us to do, we're leading to chaos in the world of whether these documents have any effect or not.
Well, I have a couple of points to make on that, Your Honor.
Please help me.
First of all, as a general summary judgment matter, because after all, what we're really talking about is a partial summary judgment on one of the issues in the case. As a general summary judgment matter, we have argued in our brief, and we argued below, that there were questions of fact, and which I suppose was proven by the extensive litigation of all these points in front of the jury, that there were questions of fact that the jury should have been permitted to decide, in addition to hearing the evidence, and therefore summary judgment should not have been granted. If I just
What
may
was the issue of fact? I mean, because either the rule is you sign and convey this document, it has effect, or it doesn't. So,
But that's a question of law.
yeah.
Okay.
As a matter of law, the question is the efficacy of the deed of release and reconveyance. Whether it is a validly executed and ready to be recorded document is a question of law.
Well, there's 3 cases where this court.
You're asking us to say intent matters too, right? And I
Well,
don't see
it
how we
clearly-
can write a law that says intent matters. on these
Well,
things.
intent matters as to any deed, whether it's intended to be delivered and whether it's intended to be effective. Any deed, there has to be intent to deliver and intent to make it effective. My client testified that even though he gave this to a third person, he never intended to give it to his brother. And the evidence...
But Ken, I'm having enough difficulty with that point. He gave it to the company. He gave it to the company to which it would end up being effective with. So I'm having a lot of trouble when you say that it was given to a third party, when it was given to an employee of the very business to which it was effective.
And it was given to an employee, but I think the dates speak louder than anything I could say. This is a document that the parties testified was signed in 2008. My client said it wasn't given to his brother so that he could not record it.
It was not given to him so he could not record it?
So he wouldn't have it in his possession to record.
But it was given to the company when the person to whom it was given left the company.
5 years later.
But your client intended it for it to be longer than that. Your client intended it to be until money was paid back or he died.
Yeah, well,
so it would be valid in that circumstance, but not in this circumstance?
Well, it's unexplained in this case why my client's brother records this deed 5 months after the notice of trustee sale is sent out in 2013, which is 5 years after the deeds were signed.
What does that violate, counsel? It may be interesting, it may be noteworthy. What does that control? How does that direct our attention?
Your Honor, I think it directs your attention to the issue of intent and delivery, and we've cited 3 cases on these points. The Parker versus Gentry case that conditional delivery can occur with a deed. That's a 1947 Arizona case, but we also cite Armour versus Armour, where one spouse was assured that a deed wouldn't be recorded, and it was recorded anyways, and the court said it was clearly a conditional delivery at 105 Arizona 284, and the Allred versus Allred case, which is also cited in our briefs, also says that Arizona recognized the concept of conditional delivery of a deed, which was our theory, which there were facts to support, and which the time gap. All of a sudden, my client notices a trustee sale, and within 5 months, his brother gets a hold of this deed of release and records it to cancel the deed of trust.
Are you saying he had no right to possess that document?
Exactly.
But it was given to his employee, and his employee, as I understand the facts, was given to his employee. The employee left at some point thereafter. When the brother is going through the employee's office, he finds the document. He has every right to that document, doesn't he?
No. And
give me a legal theory on that one, counsel.
Okay. Your Honor, that is a very, I mean no disrespect to say this, very charitable view of the facts that draws the inferences in favor of my opponents. But you're reviewing a summary judgment where the inferences were supposed to be drawn in favor of my client.
Wait.
And no, I'm going to give the court, Your Honor, I'm going to give you a theory in support
Go for it.
of what I just said.
I haven't heard it yet.
So okay, I heard you. So, the note had not been repaid and nothing had happened to my client. Those were the 2 conditions under which it was given to the manager of the golf course, who, yes, is an employee, but in effect, it was given to her to hold it like an escrowee until a condition occurs, until an event occurs.
So she was an agent of your client, but working for the people who would look forward to the receipt of that deed of reconveyance.
Well, Thomas Loegering Sr. was not one of the shareholders of the Sun City Golf Resort. It was owned by my client, 35%, and the intervener in this case, American Regents. So she was not an employee of Mr. Thomas Loegering Sr., and he fired her after the notice of trustee sale was issued. And yes, he got possession of the deed of release after he fired her, and then recorded it, and then that canceled the trustee sale. And that was our theory at trial, and that what was, I mean, you can't read the trial transcript without seeing that issue was litigated. Everyone testified about why did Ann Inman, the manager, have the deed? Why did she not have the deed? What were the conditions for her to release the deed? None of which, if you just have a summary judgment as a matter of law, needed to be presented to this jury. So as I said initially, this is a case that the jury should have decided this issue.
A question of law as to the effectiveness of the form of that document in that form.
And, Your Honor, I understand you may ultimately disagree with me, but we have argued that in the context of the facts in this case, that whether or not that deed of release was effective the minute it was signed, that it required delivery, and here it was a conditional delivery, that is not a matter of law, given the myriad of facts that existed on that point in this case, and given how my opponent chose to litigate all these facts in front of the jury so the jury would understand what happened.
And I want to be real clear on this. You're saying that it is a question of fact for the jury as to the legality of the filing of that document in that form.
No, I'm saying there's a question of fact as to the effective date when it could be filed, when it could be handed over.
So that's a question of fact, not a question of law.
I thought you were saying something else. I thought you were arguing here that it's the question of fact is whether the delivery was conditional or not.
Well, I think that's sort of the same question, but if the court perceives that as a different question, I'm arguing that as well.
I'm not trying to perceive anything. That's what I thought you had argued, is that when you started talking about conditional delivery, I thought that would be the only fact that was in dispute.
We offered evidence at the summary judgment stage and in front of the jury that it was a conditional delivery.
But you'd agree with us, or me, that the document is dated and legally meets the requirements for a deed of release. So then
I mean no disrespect, Your Honor, but the version I have of it, the date is blank.
And is the date critical to whether standing alone is an effective document?
Well, it's certainly not critical from our point of view of the way we present Arizona law on conditional delivery.
So,
no, the critical time were the two conditions that my client said were agreed to between himself and his brother.
So if it were signed and meant to be immediately, and I'm just speaking hypothetically here, if it was signed and meant to be immediately effective, whether there was a date on it or not didn't matter.
I don't think the date is the sine qua non here, whether the date was filled in or not filled in. I suppose lawyers would argue it's one fact to show that there were things to occur in the future regarding this. I would be remiss not to make that argument, but I think that the passage of years from 208 to 213.
Thank you, Counsel. Your time is up.
Thank you, Judge.
Thank you very much.
I take it I didn't reserve any for rebuttal. Thank you.
Good morning. May it please the court. I'm Kirsten Copeland, a counsel for Sun City Golf Resort, LLC. My colleague, Teresa Seifert, represents American Regents, and so I'm going to make sure I reserve some time for her. She is going to be dealing with all aspects of the attorney's fees issue. My plan is to confine myself to addressing issues of the partial summary judgment, unless, of course, the panel has questions about the Rule 59, Rule 50 issue.
I happen to actually have a question for
You're
you.
welcome to start there, then, Your Honor.
What did Ms. Inman say the intentions of George? I don't mean to be informal, but there's TJ, there's Thomas, and there's George.
And we did that throughout the entire lower litigation, so that's the only way to handle it.
What did Ms. Inman have to say about intent?
Ms. Inman never testified. Ms. Inman never provided an affidavit. Ms. Inman was not called as a witness at trial. To my knowledge.
So the one person that possessed the evidence, the information, the factual circumstances of when this would be a proper document to record was never called to testify?
Well, two parts to that, Your Honor. That is absolutely correct, but the issue of whether or not the document was a, quote, proper document to record was never litigated below. In fact, here for the first time this morning, I'm hearing the argument that somehow it was not a proper document to record based on presumably the lack of a date, I think. That did appear in the issue of whether or not George put a date on the document. That was in the appellate briefs, never was an issue below, but now the argument that somehow renders it an ineffective document, improper to record, that's new. But I think I can put that to rest simply by referring to its Trial Exhibit 12, Your Honors, as the deed of release and reconveyance. And although George did not actually fill a date in on the date line above his signature, the notary block by Ann Inman does indeed have a date on it, indicates that's the date he signed it. So the fact that he didn't actually fill that date in, quite frankly, I don't think has any effect on the validity of the document or the propriety of recording it.
The appropriateness of the signature.
Exactly, Your Honor, yes. But with that in mind, if it's all right, I want to move back a little bit on the partial summary judgment issue. We're dealing with summary judgment. The judge has to rule based on the issues and arguments as they're presented to her in the context of the summary judgment motion, and that is, of course, what happened. So we, Sun City Golf Resort, produced the deed out of its own files. They were retained it was originally given to Ann Inman, who was an employee of Sun City Golf Resort at the time. That's undisputed. And then the document was produced right out of Sun City Golf Resort's files after the litigation had commenced. And
deed of release. Just
correct.
So
yes. I'm sorry.
So
if I said deed of trust.
So in your view, Ann Inman was not a third party?
Oh, heck no, Your Honor. Ms. Inman was the general manager of the golf resort at the time, or the golf club, for lack of a better word, and she was an employee of, let's get the title straight. Sun City Golf Resort, LLC, was the trustor under the deed of trust and was also the grantee under the deed of release and reconveyance. Ann Inman was an employee of Sun City Golf Resort, LLC.
Manager. Who was
Pardon?
her manager?
The manager of the club, that was her role, but Tom LOEGERING Sr. was the manager of the LLC, so two different manager hats.
So when I say they gave the deed of release and reconveyance to a person who worked for the entity that would benefit from its filing, that's an accurate statement. They gave it to Inman, who worked for Thomas, and it was in regard to the resort.
Correct, Your Honor.
Their labors were in regard to the resort.
Both Ann Inman and Tom LOEGERING, yes.
So this isn't an agent or a third party, per se?
Well, to the extent that she's an employee of Sun City Golf Resort, LLC, she's an employee and agent of the LLC.
I'm sorry, I meant of George.
So, Tom, once Ann Inman left, whether he fired or whatever, once she left, Tom had the right to possess whatever was in her office, correct?
Sure, absolutely. I mean, she was an employee, and regardless of the circumstances under which she departed, she was an employee working at the offices of Sun City Golf Resort, LLC, same offices that Tom occupies.
So, to say that it was, I'm asking, so is delivering it to Ann the same thing as delivering it to the beneficiary of the deed of reconveyance.
Yes, Your Honor, that is exactly our position. And in fact, I'm not entirely, because I want to talk a little bit about the issue of conditional delivery, right? But also a conditional release. I think they're kind of two different things, but they get conflated. And that may help, frankly, deal with that issue there. Originally below on summary judgment, Georgia really put forth two separate arguments, related but separate. And one was that the release was conditional. In other words, the release is not effective unless and until the debt's paid, okay? And then the second argument was that delivery was ineffective because it was Georgia's understanding, didn't actually happen that way, but his understanding was that the deed of release and reconveyance was to be held by a third party and then only delivered upon satisfaction of the condition. Either of those two things at law are perfectly acceptable means of dealing with a conditional release. So, in other words, if I want to say, I could go ahead and execute a deed of release and reconveyance that is itself conditioned upon some event, payment of a debt, by saying, upon payment of the debt, I release all right, title, and interest in this property. And I could go ahead and deliver that deed to whoever was going to benefit from that release, and that condition would still be operable because it's right there in the deed that it's not operable unless and until that condition is met. And in fact, that's pretty much what happens in the case of a beneficiary deed. You execute the beneficiary deed, but the beneficiary deed, right by its own terms, is not effective until the death of the grantor. But that's not what happened here. Here there is no conditional language in the deed. So the only option then would be to do an escrow, which happens every day in conveyance of property, is you deliver that deed that is unconditional on its face, you deliver it to a third party to hold pending compliance with the condition, payment of whatever needs to be paid.
So, but the conditions are laid out for the benefit of that escrow agent or whoever's holding the document. So there is a record of what the intent is.
Correct.
So it's either going to be written into the document itself or it's going to be provided in another document to the escrow agent.
Correct.
Thank you.
Yes. And so the problem here is there were two options for George to pursue to accomplish what he testified he wanted to accomplish, but neither of those options actually occurred. Either a condition that's right in the deed itself that everybody can see so that the parole evidence rule doesn't create problems, or an actual delivery to a third-party escrow. What actually happened here was an unconditional deed, a deed unconditional on its face, was in fact actually delivered to the grantee under the deed of release and reconveyance, which was Sun City Golf Resort. And that's
if he had attached a letter to the deed of reconveyance when he handed it to the manager and said, "Here are the conditions for my delivery. I'm going to let you hold it." Would that be enough?
I think that would we would probably be back on appeal, to be quite frank, because even if it's attached to the deed itself or is included with the deed, I think it would still arguably be parole evidence. However,
but how do you address the cases that he cited that allow some form of conditional delivery to be effective?
And
those correct me if I'm wrong, those weren't traditional escrow arrangements.
No, I don't think anybody would consider them traditional escrow. But I think the case that you're referring to specifically was, let me pull out my last note here. Terrible with remembering the case names. I believe that one was the Hutton v. Kramer. And in fact, there was a deed unconditional on its face that included a separate letter with it with written instructions that was actually held in the grantee's bank box. So not a third party. It was placed in the grantee's bank box and with instructions that the intent was to actually, once the grantor passed away, that the deed would become effective. And it's kind of a predecessor, quite honestly, to a beneficiary deed.
But it would have to be probated effectively, at least in this state. If it's in their safety deposit box, how does that then attach to the transfer at the time of the death?
It was in the grantee, not the grantors.
Did I misspeak? That's entirely possible.
No,
Yeah.
I think you said it correctly.
Okay, yeah, the person who would benefit, who was actually going to obtain the property after death, it was in that person's bank box.
Thank you.
Sorry. But I wanted to point out, though, that if you look and actually read through some of the language of that case, some of the language of that case says that after it was placed in the grantee's bank box, the person who was going to ultimately receive the property, that nothing in the Grantor's Acts or in his written notice accompanying the deed, which is, I believe, what Your Honor was referring to, negates the view taken by the trial court in its findings that the grantor intended irrevocably to place the deed in the bank box. So I think that they were litigating a bit of a different issue there. It was an issue about whether or not the grantor had the right to revoke, essentially, this deed that had effectively been delivered unconditionally to the grantee. I think that, and so it's really litigating a little different issue. I also wanted to address Armour v. Armour, because it's I think that one's actually, I don't think it's on point, but I think the reason that Armour v. Armour, that was the case where a wife, apparently according to the ruling of the trial court, was essentially defrauded into signing a quitclaim deed that she understood was only to be effective if both she and her husband were killed simultaneously. The difference between that case and our case is the wife actually didn't deliver anything. The wife executed the deed, but it was the husband who ultimately actually delivered to his mother, who was the beneficiary. So she never actually accomplished delivery under that case, and so in that case, and so the court found that she was essentially, that her consent, she never gave consent to the actual delivery. In this case, George did actually deliver the deed. In fact, he signed it and handed it over to an employee of the grantee. So those are the two main distinctions there. I want to make sure that I leave enough time for co-counsel, but I did want to very briefly address the issue of objection to the jury instruction on the 33-420 claim. The only objection that was placed in the court below to the 33-420 claim was the word objection next to the title of the jury instruction on the original document under which we submitted the jury instructions to the court. And as we set forth in our brief, that's not a sufficient objection. You got to provide what exactly the objection is, and you got to provide a legal basis for why the instruction is problematic, and that was not done. So unless Your Honors have any more questions for me, I'm going to turn it over to my colleague.
Thank you.
Well, actually, let me quickly. Setting aside the waiver issue, tell me why the instruction was permissible. It does seem like almost just right up to the edge of a directed verdict on that issue.
Oh, because and I'm glad you asked, because I actually had intended to address that up front, is what was reserved after summary judgment, what was not decided, the fact issues that were remaining were for lack of a better word, the wrongful nature of the conduct, the knowingly, willfully, wrongfully conduct that are essential elements of all of the claims. It's an element of 33-420. It's an element of the slander of title claim, and it's also an element of the interference with contract claim. And so summary judgment couldn't address those issues on summary judgment. Those are almost by definition fact questions. So the only issue was, as far as the jury was concerned, that delivery and acceptance and the effect of delivery and acceptance of that deed of release and reconveyance established as a matter of law that the deed of trust was extinguished. Then beyond that, the jury still had to address the issue of George's conduct outside, given that knowledge, which he, by the way, did testify at trial that he remembered that he had signed and delivered the deed of release and reconveyance, and he also testified pretty extensively that the reason that he attempted to foreclose on the deed of trust had nothing to do with the debt. It was about creating leverage and trying to oust his brother as manager of the LLC. Those were proper and appropriate issues for the jury to decide rather than on summary judgment.
Thank you, counsel.
Good morning, Your Honors. My name is Teresa Seifert, and I represent American Regents, the intervener. I will also address the attorney's fees issue as to Sun City itself as well. And again, with the informality of the names, I apologize. Normally I don't, but we do refer to them as Tom, George, and TJ because their last name is all the same. Briefly, unless the court has any questions, as to American Regions, we believe that the court rightly denied George's application for attorney's fees. The court gave a pretty extensive ruling as to why she denied those attorney's fees. Attorney's fees under the statute aren't mandatory, and she did set forth several reasons why she did not believe that they had those attorney's fees, which we put in our brief. So unless the court has any questions about that, I will just limit most of the argument to the Sun City one. And in addition, I would note as to American Regions, in their reply brief, they don't address any of the issues that we had in our response, and therefore we would argue that they're deemed, they've conceded those issues that we've raised in our response brief. As to Sun City Golf Resort, the court really took a twofold approach. She awarded attorney's fees under the statute 33-420 and under 12-341-01. As to the argument as to 33-420, the fees are mandatory if the Sun City Golf Resort won in that instance, that claim. And they did win. Granted, they only won the statutory minimum for damages, but the fact remains they did win that claim. Attorney's fees, if I understand what opposing counsel was arguing in his opening brief, that the damages were somehow limited to $5,000 and therefore we shouldn't get attorney's fees based on those small amount of damages. The language is clear that there's an and. It's the $5,000 for the damages and reasonable attorney's fees. There was never any argument made below that the $77,000 in attorney's fees for a 3-year litigation were somehow unreasonable.
Why wouldn't we, under China Doll, send this back to the trial court and say, you need to kind of break this out claim by claim? Yes, Sun City and your client are entitled to award for attorney's fees on the statutory one that they won, but he's also entitled to attorney's fees on the claims that he won at trial. It seems like there's kind of the court took a winner-takes-all approach when that doesn't necessarily reflect the case law.
I understand, but the case law also supports who is the winner overall. And in this case, the winner overall is really Sun City in the essence that their main claim was to stop the foreclosure of the property. It was a $2.5 million golf course that George was foreclosing on.
And they got that when summary judgment happened. So then afterwards, up until then, let's say I'm completely on board with you, all the fees up until summary judgment. Then you've got the trial, which is a whole another batch of fees, and the results were much more mixed there, wouldn't you agree?
They were mixed, Your Honor, but when you look at the overall intent and the fact that all of those claims were intertwined with each other, then there is still, under the case law, an opportunity to look and see who the overall prevailing party was. And in this case, the court determined that the overall prevailing party was Sun City Golf Resort.
And our standard of review on that question is an abuse of discretion?
It is under an abuse of discretion, and as long as there's reasonable evidence in the trial court for the trial court to take the position that it did, this court generally affirms that decision. And as the judge did in her minute entry, she did set out a very well-reasoned minute entry regarding why she was awarding fees to Sun City and why she was not awarding any fees to George's attorneys.
Someday I want to hear an attorney say that the decision was well-reasoned when it goes against them, because it's always the person who likes it that calls it well-reasoned.
I understand that, Your Honor.
Is it sufficient if we resolve this under one attorney's fee statute and not the other, or are you arguing that we need to find under both?
I think you can resolve it under one or the other. And as far as the statutory claim, the fees are mandatory. There was never an argument down below that there should, of the $77,000, only this amount should be applied to, if the court was going to award fees, only this amount should apply. That argument was never made down below. It was an all or nothing thing. They didn't deserve it. It was either the court should award Sun City no fees because they didn't really win and George was the winner, or that, but there was no argument that of the $77,000, Sun City would have only been entitled to, like, say, for example, $50,000. There was never any argument that any of the entries under the China Doll affidavit that were submitted, that those fees were somehow unreasonable.
Thank you, Counsel. Your time is up. We appreciate your arguments today, and we'll take the matter under advisement and issue a decision in due course. We stand adjourned.